Hey, all persons having anything to do before the Honorable, the Justices of the Appeals Court, now sitting in Boston, within and for the Commonwealth. Draw near, give your attendance, and you shall be heard. Now see the Commonwealth of Massachusetts, court is open, please be seated.
Good morning and welcome to the Appeals Court. I'm Chief Justice Mark Green. To my right and your left is Justice Vicki Henry. To my left and your right is Justice Joseph Ditkoff. We have 6 cases on the list for hearing this morning. We expect to take them in order, although we may adjust the order if circumstances warrant, and I will advise if that is the case. The first 3 cases scheduled for argument are all criminal matters, followed by the 3 civil matters on our list. We are familiar with the arguments that you've made in your briefs with the factual and procedural history. You needn't go over all of that. Each side of the V has 15 minutes to argue, and there is no rebuttal. If there's more than one attorney arguing on either side of the V, let us know ahead of time how you'll be dividing your time. If you reach the end of your time before you reach the end of your argument, you may rest on your brief for whatever remains, and if you reach the end of your argument before you reach the end of your time, there's no need for you to keep talking to us. The time, by the way, as you are probably aware, is indicated on the digital readout. There are 3 lights. It begins at 15 minutes with the green light. At a minute and a half left, it turns to yellow. That's a good time for you to begin wrapping up if you've not done so already. And when it reaches the end of your time, it will turn red and start blinking. The first case on the list for hearing is case number 2023 P306, the Commonwealth versus Jose M. Melendez, and this case is partially impounded, just as a reminder to not place the impounded material into our public hearing.
Good morning, Your Honors. Attorney David Rotundo for Mr. Melendez. At the close of the evidence in this case, the defendant argued that there was insufficient evidence to convict him where the complainant could not identify the defendant. So essentially, the main issue, really the only issue in this case, has to do with whether any rational trier of fact could have reasonably found the defendant had committed the alleged acts. There was no identity by name or visual identification of the defendant in the courtroom. Jim, during direct examination, was asked if he knew someone named Mr.
When you say Jim, you're using a pseudonym for the name of the victim.
Yes, Your Honor. So Jim, during direct examination, was asked if he knew someone named Mr. Melendez. He identified him as a teacher guy from Puerto Rico, bald, white, or black man. I don't know. He stated he remembered his name after the prosecutor asked him if he knew someone named Mr. Melendez. Now, on cross-examination, he acknowledged that he talked to Jackie from the district attorney's office 3 or 4 times regarding Melendez, and she told him what to say. Jim acknowledged that Jackie helped him remember details of what had happened since he had forgotten. The question is, do we have enough evidence to confirm the identification of the defendant? Now, the Commonwealth cites the Coates case as instructive. In Coates, the defendant, the victim's mother's live-in boyfriend, was charged with indecent assault and battery on her daughter, the daughter being 5 years old. So the daughter couldn't identify the defendant during the trial, but the court found sufficient evidence in that case that the defendant committed the offense where the defendant lived with the victim and her mother, watched the victim when the mother was out, assisted the victim in daily activities, and moved out after the victim disclosed the abuse.
Why don't we talk about the evidence that we have in this case? As you pointed out, the victim, as in Coates, did not identify the victim in the courtroom. But there were a variety of indicia that, when viewed together, tended to point in the direction of the defendant, right?
Yes.
The surname, the fact that the defendant was employed by the school at the relevant times and was the only person with that surname that was employed by the school in those times, and in his role with the school had regular interactions with the classroom in which the victim was enrolled. Right?
Well, that's true. But I would argue that the circumstantial evidence, if we look at the Coates case, didn't include the possibility of other perpetrators. Now, that's kind of the distinguishing factor in this case. We had two teachers that testified that during the school term, there were 12 teachers and 8 paraprofessionals.
But there was no other teacher with the same surname. And we have, I mean, this is, if there were 4 different people named Melendez, but they all had different first names, that might be a different situation, or even 2. Here we have one person with the name described, and that person also was a teacher, as described, and had access to the classroom and the victim during the relevant times.
Right. But Jim never stated that name during the trial. He never identified
He did
Melendez.
state the name. You described that statement. You quarrel with the manner in which that name came forward, but that goes to the weight, not the sufficiency of the evidence, doesn't it?
Well, that's true. I agree with you, but...
Okay, but you're challenging the sufficiency, and so in order to make that argument rest on a legal foundation, you're going to have to come up with something different then, I guess.
Right. And well, that is essentially what we have. I mean, I was trying to make the distinction here of cases where the circumstantial evidence was enough. In our case, I'm arguing that it's not, because there's a possibility that...
You have a case, rather than comparing this to cases where the circumstantial evidence was enough, because that's what the Commonwealth suggests is the case in this case as well. Do you have a case similar to this one where a court has held that the circumstantial evidence was not enough? What's the closest comparator that you have?
I don't have a case.
Okay.
So where in the transcript is this? I know you disputed how the name came in. So where is that?
Well, I think there was testimony, transcript 3, volume 3, page 45, 46, that he identified this teacher guy from, after he was asked the question, do you know someone named Mr. Melendez? Can you identify Mr. Melendez? I don't have the transcript in front of me, but essentially, he identified him, and he also qualified that with saying, I don't know. And he could never make a visual
Okay,
identification.
yeah, you are correct about your record citation. So you're saying the name was given to him by the prosecutor as opposed to asking, asking.
And I realize it's it was a proper question, of course, but, the fact that it appears that he could only identify him after he was given the name and couldn't identify him in the courtroom, and there were no other measures to kind of make an identification with him.
Was there an effort to elicit, without a leading question, the name of the perpetrator? Or when you say he wasn't able to identify, it was really that he couldn't point out the defendant in the courtroom?
Well, he couldn't identify him.
Correct.
And there's some
but there was no open-ended question that sought to elicit from the victim the surname of the defendant.
There was not.
It was the way the question was posed to him. Yes, it was leading it as to form, and had there been an objection, the objection might well have been sustained in the discretion of the judge, and then we would have found that out. But here we are, and we're looking at the sufficiency of the evidence.
And I do reference, facts, not in evidence in closing that may have influenced the jury. The fact that, the Commonwealth stated that, implied the lack of identification based on poor eyesight of Jim when there was really no evidence in the case that Jim, he wore glasses, but there was no evidence that he had, poor eyesight.
I thought the teacher said he was able to see things only as long as he sat closer. Is that wrong?
But I think there was some other qualifying evidence from the teacher that he was, I don't think it was that he couldn't see, he liked to be closer, but it wasn't that he had to be. I mean, that is how I interpret it.
The teacher offered the explanation that the reason they sat the student toward the front of the classroom was because of poor eyesight.
If that is how we're reading the transcript, I mean, I can't deny that. But There was no testimony as the Commonwealth presented that Jim couldn't see particularly far. And those facts, I would argue that were not in evidence, that he couldn't see particularly far. But I agree that an inference can be made based on the fact that he was seated in the front of the classroom. So essentially, I mean, that's essentially the argument in this case, and I rest on the brief for anything else.
Thank you.
Thanks.
For the Commonwealth?
Good morning. May it please the Court, Kenneth Steinfeld for the Commonwealth. I don't have a whole lot to say this morning to add to what's already been said in my brief. I do just want to add to Justice Henry's question, not only pages 45 and 46, but 47, also of Volume 3, has a complete, that tells you exactly, that's where the basis of the argument comes from. And of course, there was testimony that the student, that the victim was not able to see the blackboard in the classroom. So that's why the teacher put him there. There was evidence both from her and from the aunt that he did not like to wear his glasses. So because he did not like to wear them, she put him, and I think it's absolutely an obvious, reasonable inference that that was because he was nearsighted, therefore making it possible and certainly an arguable inference that he did not identify the defendant in court as the perpetrator because of his eyesight, among other
We don't know whether he was wearing his glasses on the stand, do we? I couldn't.
No, there is no evidence of that, one way or the other. But I think it is inferable from the comment from the prosecutor, which was not objected to on that grounds, that he couldn't see the defendant, that he wasn't wearing his glasses. So there's no direct evidence, but I think it's a reasonable inference. But I don't think it's essential. Because there was evidence that he was nearsighted, so it's a reasonable inference that the prosecutor asked the jury to draw. The mere fact that the victim said that he had been abused by a bald Latino paraprofessional in Ms. Brown's classroom by the name of Melendez is absolutely sufficient evidence to prove identity, that he was in fact a perpetrator. And there's no case that implies otherwise, and there are many cases that suggest that that is sufficient.
Why should the prosecutor have been allowed to give the name to the victim where, in this circumstance?
Well, she started the conversation by saying, I want to talk to you about a Mr. Melendez, and she's trying to orient this victim who has very difficult time speaking and communicating, and then she asked him, do you know his first name? And the victim says, no, but I know that his name is Melendez. So the victim adopted what she had said as his own testimony, and I don't think there's anything wrong with it, as the guide to evidence says, that a leading question is permissible in circumstances just like this in order to draw out from a witness to, she didn't try to force a version of the case for which there was no evidence. I think it's a perfectly acceptable way for her to start her examination of this particular victim to get him focused on what they are there to focus on. And there was no objection to it, and it was not objectionable. And I think that if it had been objected to, as Chief Justice Green has said, it might have been sustained, but it very well may have been overruled because of the nature of the victim, who was childlike in almost all of his qualities. So I don't think it matters either way. Had there been an objection, she could have said, by that time the name Melendez had been uttered, and the child no doubt would have said that it was Melendez. So I don't think there's any harm from the fact that she started off. She brought up the name first, and then he affirmed it. So I don't think there's a problem with that. But even putting that aside, assume that that is a problem. And of course, it doesn't matter for sufficiency because you take into account both the properly admitted and the improperly admitted. And even if there were a doctrine that says that an answer provided pursuant to a suggestive question should not be considered, as I said, you have these other factors that clearly, when there's identity of name as there was here, you only need a little bit of corroboration, and those other factors that I mentioned that squarely, that totally identify and totally properly characterize this defendant as the perpetrator was enough to prove identity.
So the defendant argues that the prosecutor misused the testimony of Dr. Block about the focus on the weapon.
Yes.
Why is the situation here where the victim knew the defendant for 2 years, why is that not different from the expert's testimony?
Oh, it is different. I don't think it's a very strong argument. His claim is that not that the testimony from the expert should not have been admitted, but that the prosecutor mischaracterized her testimony in her closing. She absolutely did not. She made an analogy between a victim of an armed robbery from a stranger who focuses on the gun with the victim in this case saying that she focused on his penis rather than his identity. I just don't think that's a great...
Why, you said rather than his identity. I didn't see that. I saw the prosecutor say he focused on the penis rather than the tattoo, but I didn't see identity. What am I missing?
I thought, and I may be wrong, that it was not connected to the tattoo. It was a general point that she was the victim was unable to identify him in court as the perpetrator because he was focused on his penis rather than that fact.
At the time of the assault.
Pardon me?
At the time of the assault.
Yes, at the time of the assault. And I don't think, and I may be wrong, that it has anything to do with a tattoo or not. I don't think it does, but if the record says it does, then it does. If the members of the court have no further questions, which of course I'm happy to answer, I'll be
Seeing
happy to
none,
rest of my brief.
thank you.
Thank you.
The next case on our list is case number 2023 P387, the Commonwealth versus Frank R. Lamond, and this case is also partially impounded.
Good morning. May it please the court. Attorney Justin Dashner for Mr. Frank Lemand. So Mr. Frank Lemand was convicted of violation of a restraining order. As part of this case, one of the critical elements to proving that he violated the restraining order is that he knew about the order. The Commonwealth's primary evidence that he knew about this order was achieved via the entry of a return of service showing that he was served.
You're aware that that issue, the propriety of that form of evidence for the purpose of knowledge, was determined by an opinion of this court, Shankwan, back in 2011 or so?
Yes, Your Honor.
And are you suggesting that Shankwan is not good law?
Your Honor, I'm not necessarily suggesting that it's not good law. I am suggesting that there has been subsequent cases that change the framework in which this is examined that would allow this court to revisit that issue. Under Michigan v. Bryan and subsequently Wordsworth, the court did simplify the test. Essentially, the primary purpose of the document was to provide an out-of-court substitute for trial testimony. The concurrence in Shankwin sort of opened a potential door to examining this, and that not all documents that are administrative in nature, business record exception type documents, are necessarily not testimonial.
So how did the subsequent cases change the framework?
Well, it's a minor difference, admittedly. The Gonsalves framework was sort of a two-part.
Sorry, the doors are opening and stuff. I just literally can't hear you. So let's let them get seated.
Of course.
And maybe hold the door for a second. Can you just speak a little louder?
Yes, Your Honor. My apologies.
It may be a subtle difference, but those can be significant. I need to hear you.
Yes, Your Honor. The Gonsalves framework, which was used in Reddy and in Shankwin.
Okay, let's try it again. Really, bellow it out like you're on a stage, okay?
Yes, Your Honor.
Outside voice.
Outside voice.
The Gonsalves framework, which was used in Shankwin and Reddy, was sort of a two-part test. First, they examined whether it was whether it was per se testimonial. This would be in-court testimony, depositions, affidavits, that sort of thing. I would certainly argue that the return to service is similar to those documents, but the court found otherwise.
Could I pause you for a moment? Can we just prop those doors open because there's somebody else coming? I just saw him going down the hallway. I just need to let this poor man make this argument, and the doors. At least that one, if we could just prop that one open. Well, don't worry about the time.
Yes, Your Honor. So the second part of that test is if it's not testimonial per se, these type of documents, the affidavits, a deposition, that sort of thing, then is it testimonial in fact? Is it a document that could be reasonably anticipated for use at trial? Again, I would argue, even under that framework, that this return to service could be anticipated to be used for trial. However, the subsequent case did simplify that. It just looks at the primary purpose of the document. There's sort of...
And that in terms of, to the extent that that worked, a change in the approach or the perspective that we apply would tend to simplify in a way that makes the argument you're pressing here more difficult rather than less difficult, right?
Well, Your Honor, I think the issue with the return to service is it does sort of serve two primary purposes.
It is a procedural vehicle necessary to record on the docket of the underlying case that the necessary steps have been taken. Yes, it does serve an ancillary value in these circumstances where there is a violation afterwards. But I think Justice Wallahojan's opinion in Shanquan made the observation that at the time of the issuance of the order that there's no anticipation that there will be a violation.
Yes, Your Honor. However, this is a document that says right on it that this could be used for prosecution in a criminal matter. The district court guidelines for service prefer in-hand service so that it can be used for a future prosecutorial purpose. An important case, the Parento case, which had an RMV certification that notice had been sent to the defendant in the matter, that was found to be testimonial. The court found that.
But that's because it was produced in response to the litigation itself.
Yes, Your Honor. I do understand that there's a difference in the timing of these documents in Melendez-Diaz and in
the triggering event, not just the timing.
Understood, but I do think the primary issue here is the fact that the document is proving, and it's that a critical element that the prosecutor needs to prove a fact at trial. And certainly any court officer who serves this document is well aware that it might be used at a subsequent prosecution. I think the difference on the RMV case, where the court found that administrative documents that were generated by the RMV would be admissible under the business record exception, but that this was not admissible because it was prepared directly for trial.
I noticed that you, possibly anticipating some resistance on our part to overrule one of our prior cases, that you applied for direct appellate review.
Yes, Your Honor.
And the Supreme Judicial Court declined to take the case on direct appellate review. So having been presented squarely with the contention that that our case should be not merely revisited but abrogated after a dozen or so years, the SJC, at least at this point, has declined that invitation.
That's true, Your Honor.
And I understand, of course, that it would certainly be within your rights to seek further appellate review should we decline the request that you're making and decide to leave Shanquan alone.
Yes, Your Honor.
Okay.
So, Counselor, if you're a judge, district court judge sitting in civil session, you need to know whether the 298 order got served, because if it doesn't, then you have to try to make other forms of service. And you can't really hold the next hearing till you know that the defendant has gotten notice of the order and when the next hearing is. I mean, so that's plain. So why isn't that the primary purpose of this document?
The use in civil matters, Your Honor, is that?
For use in the 209A, both to determine whether additional attempts at service have to be made and to determine whether you can hold the next hearing properly.
Well, Your Honor, I would suggest that's slightly different than whether this document could be admissible at a criminal trial. I understand your point that this sort of administrative purpose for the trial courts is the primary purpose. However, again, it's my point that at least there's an additional primary purpose, I guess, that this be used at a criminal trial. That's mentioned right on the return of service. It is a court officer essentially testifying to a fact that a defendant has very little ability to challenge.
Where does it say on the returns of service that this will be admitted in a criminal case?
Your Honor, I believe it's right at the top of the return of service, right on the document. It says violation of this order is a criminal offense, and this order shall be enforced by any law enforcement officers. So implied in that fact is that it would be used in any criminal violation of the order.
How so? There's nothing on the face of that. It warns them the violation of the order is a crime, but it doesn't say anything about the form of proof that could be presented.
I think the inference is reasonable that a court officer who is serving this order where it says that this could be violation of this order is a criminal offense, that any documents that are involved could be used in a future prosecution.
Well, it turns out that they can,
Yes, Your
because
Honor.
that's what we've held.
Exactly, yes.
Okay.
So turning to the defendant's second argument in this case, we look at the prosecutor's argument in the closing statements about Mr. Lamond's supposed admission. The exact language is, I would argue, at least confusing, if not misleading. The prosecutor argued that Mr. Lamond made an admission to either to Ms. Fay or to the complainant in this case. It's not real clear from the language. There was a clear objection made by defense counsel and an argument for mistrial after this. This statement in the middle of a closing could be very prejudicial. The fact that the jury could misinterpret this statement to mean that the defendant made some sort of admission while he was at any point would certainly prejudice him. It misconstrues Ms. Fay's testimony about that admission, and the statement is confusing. If the jury takes away that the defendant makes some sort of admission in this case, a case that's very, that comes down to whether the contact between Mr. Lemand and the complainant was incidental or accidental, or went beyond that. An admission that he spoke to her would certainly give rise to an issue.
If he said, I talked to her first, then he's violated the order regardless of whether he directed that at Ms. Fay or at the victim, right?
Well, it's not clear when he says I talked to her first. I mean, if he is talking to Ms. Fay, I mean, I guess it would be a discussion when Ms. Fay comes out to talk to Mr. Lamond, and it's not clear who he's addressing that to, and whether it's...
I get that. If he said, I talked to you first, then he's fine. But if he said, I talked to her first, then he's violated the order regardless of who he directed. Isn't that right?
I see, yes. Well, Ms. Fay had sort of two versions of events that she testified about. On direct examination, I think she said that he said to her, I talked to you first, which would be would be Mr. Lamond talking to Ms. Fay and not referencing the complainant. However, on cross, she sort of had two different versions. of events. I think the issue here is the lack of clarity and the confusing nature of the statement. Certainly if it was clear via the testimony that Mr. Lemand made an admission to, a third party, whoever it is, about speaking with the complainant in the matter, that would be admissible and that would be no issue here. I think it's
Why
just
isn't this a situation where, she gave her testimony, it was a little confusing, and the Commonwealth marshaled the evidence in the light, in the light most favorable to the Commonwealth to say he made this statement, and that really was up for the jury to decide?
Yes, Your Honor, I believe it's just the way in which the statement was made. It's a very small point.
To the extent it was confusing, the prosecution is entitled to ask the jury to reconcile that confusion in the manner that's most favorable to the prosecution, so long as it's consistent with a fair reading of the evidence.
Yes, Your Honor.
And you're saying that the uncertainty was so pervasive or profound that that was not a fair characterization of one way the jury could understand and reconcile that testimony?
Yes, Your Honor, I am.
Okay.
And just quickly moving to my last point, there was a reference about the defendant having been arrested. Our issue with this point is that this was prejudice to the defendant. Prejudicial value outweighs any clear purpose for that evidence. It also lends credence to the fact that the arresting officer at that point clearly believed that there had been a violation of the order, and that was inappropriate and requires reversal in this case. So.
All right.
Address on my brief.
Questions? Thank you. We'll hear from the Commonwealth.
Good morning, if it may please the court. Assistant District Attorney Timothy Ferreter from Middlesex on behalf of the Commonwealth. And I'll pick up with the second issue. And I would say, going off your point about the prosecutor marshaling the evidence in favor of the Commonwealth, he really did more than that in this case. He recognized the confusion and he went through it for the jury in the different ways that they could conclude that the interaction between Ms. Fay, the victim, and the defendant was still a violation no matter what was happening. He's 5 or 6 feet away from the victim during this interaction. He's either talking to the victim that...
So let's just pause on this, because I just
Sure.
was refreshing myself as to Ms. Fay's testimony, and
Yep.
she's, sometimes witnesses give testimony, and then through further examination or cross-examination, it becomes very unclear. But she literally starts off and says, I don't know if he said I spoke to her first or the other thing. So is that all the evidence there is on this particular point? Because then I don't see how a jury gets to pick. If the witness herself says, I have no idea.
So sure.
Which one of these?
Yeah, so, I mean, first of all, there's no dispute that there's an interaction going on between Ms. Fay, the victim, and the defendant, and that interaction's in violation.
Well,
of
but
the
I'll go
restraining
back
order.
to Judge Ditkoff's point, because you seem to be arguing in this situation that even if the defendant just spoke in the victim's presence so she could hear it, that would be a violation.
Correct, because that's contact, and this court has interpreted contact broadly. So if I'm 5 or 6 feet away from you, Justice Henry, and you have the restraining order against me, and I turn to talk to Justice Ditkoff, you can still hear my voice. Under the case law, that's still contact. Contact isn't direct one-to-one, communication. Contact is interpreted very broadly by this court for like waving down the street and stuff like that. So if there were having interaction between the 3 people and one of them has a restraining order, that's still contact in violation of the 209A
If he
order.
was actually walking away from her at the time as he should have been, and it uttered that, would that still be contact?
Yes.
That seems a little unjust, doesn't it? If he's doing what he's supposed to do,
Yeah.
which is moving away from her, and, he speaks to another person?
Sure, the jury could decide whether this was accidental or incidental and whether he was taking immediate action to get away. But the point of a 209A order is to create a zone of safety around the victim. And in this case where he's 5 or 6 feet away from the victim, if he's either talking to Ms. Fay so that the victim can hear, or he's talking Ms. Fay so the victim can hear, or talking directly to Ms. Fay, well, he's still clearly within the 100 yards. He's not making a much of an effort at that point
Well,
to quickly
I could
get away.
understand that if his comment was, I'm going to get her one day, but if his comment was, I asked the librarian for help first.
The contact doesn't have to be threatening. It can be a wave from down the street. There's a lot of different
I know, but if
209A
he's,
order
you know,
cases.
because people do, we get these cases all the time. Somebody goes into a store and sees the other person's there, they need to immediately
Right.
immediately
Leave.
move to withdraw. But like you're saying, basically, they can't speak.
Well, they can't stand there and say, well, let me finish my business of getting the librarian to print out a statute for me. I can't. It's not his role in this situation isn't to finish his business at the library. It's to immediately undo the restraining order violation. So really, under any scenario, he's continuing the interaction. He's continuing to stay 5 or 6 feet away from her longer than is necessary, because he doesn't have to wait to get the statute at this moment. He can leave, and he doesn't do it. And then when he does leave the library, he sits outside the library within 100 yards of her.
Well, if that's true, I don't get any of this closing argument. Why wouldn't you just say, it doesn't matter what he said, because as long as he talks in front of her, he's guilty, end of story. And then why would you go through all this complicated stuff about what she said or didn't say?
Because I do think it was not a mischaracterization of the testimony. He actually went through all the different, in the closing argument, he went through the different testimony, acknowledged the confusion, but said, he's either talking directly to the victim that I was speaking to, I asked Ms. Fay first, or he's admitting to Ms. Fay, I was talking to her first, referring to the victim. So he went through all the different testimony and was explaining that under any scenario, he's still in violation. And this wasn't really disputed by the defendant. In the closing,
If you wanted to do you had to leave the courthouse theory immediately, wouldn't you have had to show that he didn't have court business at the courthouse? I mean, isn't he entitled, if he's got a Superior Court case going on like the victim did, to be in the courthouse even if she's in the courthouse, and that means that he's within 100 yards of her?
Well, he said he was going to do research at the library, so I didn't say he had the defense wasn't that he had a court case, it was that he was going to do research, and that's something he could do later. It wasn't he had a set time to be there, so no. Excuse me, so I think that's different. If they both had the 209A hearing, and they're both in the courtroom after, of course, he could be within 100 yards of her. That would be incidental contact. But he didn't have a court date, he was there to do research, so that's different. And then turning to the return of service issue, Shane Kwan was correctly decided. As this court said, the primary purpose is the routine administrative functions of the court system, and it can't be the primary purpose to create a substitute for testimony when there is no criminal case and there may never be a criminal case. So that's why the primary purpose in this case is the 209A order function and not a substitute for testimony. And the difference between the Gonsalves test and the Wordsworth test is very slight. I don't really think there's be any real change in any different types of records that would come in under Gonsalves that wouldn't come in under Wordsworth. And I'll rest on the third issue on my brief unless there's any questions.
Well, what was the purpose, probative purpose of testimony that the defendant was arrested?
Sure. So the probative purpose in this case was very relevant in this case. It was that the defendant was outside the library waiting unrestrained until he was arrested, so he had an opportunity to move outside the 100 yards and he chose not to.
No, I mean, you're kind of blurring two things. The testimony that he's still sitting there on the bench when I come, I can understand why that's admissible, but why do you have to add, and then I arrested him?
Because then it leads to the next question. Before he was arrested, was he, free to go, move on his own? So that's what the relevancy of that testimony was.
You testify that he was arrested to show that he was free to go before he was arrested?
Correct. Because there's some dispute in the testimony whether there was a court officer with him before, and Detective Peace's testimony was there was no one with him, and until he was arrested, he was free to move.
I've seen a lot of cases where people get seized and aren't free to go long before they get arrested. I never understood being arrested as showing that you were free to leave before you were arrested.
This case, the testimony from Detective Peace, there was nothing. She was inside the library talking to people, so there's nothing. He wasn't seized. She hadn't interacted with him yet. So there's nothing preventing him from moving outside the 100 yards. And he chose not to on his own. And there was also a limiting instruction in this case, as requested by the defendant. If there are no further questions, I'd rest on my brief.
Seeing none, the case is submitted. We are going to move slightly out of order and take as our next case the impounded matter concerning the termination of parental rights, case number 2023 P579, and then we will take a brief recess following the argument in this case and resume with the third of our criminal cases and the other two civil matters after that. I'm sorry, not termination, but custody, but child welfare case nonetheless. And I do understand that counsel on each side will be dividing their time.
Yes, Judge.
Okay. You may proceed.
May it please the Court, Your Honors, Gary O'Brien on behalf of the appellant mother in this case. This case involves, we presented two arguments before the Court. The first one is with regard to, under the cases of Means and Reza, was the failure of the trial court or the trial court not appointing counsel for mother in these proceedings. And then the second case, that there was not a nexus shown in terms of the issues raised with regard by the department against mother as to why mother was found unfit by the trial court. They're a little bit intertwined in some sense, that mother did not have counsel at trial and wasn't able to kind of fully fill out or address some of those issues, and some issues there weren't motions in limine, there weren't objections or other things that would be able to be offered if mother did have counsel.
Did mother have standby counsel at trial, or were they at that point discharged?
So mother had, I believe it was in March of 2022, mother was appointed counsel, and then that counsel withdrew, and the trial court appointed mother standby counsel with strict guidelines as to what standby counsel could do, couldn't file motions, couldn't subpoena or otherwise. Standby counsel at the beginning of trial withdrew, so mother proceeded pro se without standby counsel at trial.
In this case, the judge did keep warning the mother that they didn't have a limitless supply of attorneys. What more do you think the judge should have done?
So I think the guidelines and kind of the test are set out in Means and the Commonwealth of Means and then Reza, and basically in those instances the trial court is under the Means is the real critical inquiry is when the trial court warns mother in this case that an express warning that I'm appointing you one more counsel, and this counsel, you need to work with this counsel, and if you come back and you're not able to work with counsel at that point in time, then you're going to have to proceed pro se. And then also under
So I don't mean this as a hostile question. I really want an answer. On the February 10th hearing, when the judge says, what I'm saying is I will appoint one more attorney for you, why isn't that what you just said? What's deficient on that?
And I think that leads to one of the other issues that I wanted to discuss is that I think under Means and under Reza, there were, the judge appointed a fifth attorney and said, this is the last attorney, you need to work with them, and then appointed 3 more attorneys, a total of 8 attorneys, before finally finding that mother had waived her right to counsel by conduct through Means. I think what's required under, our argument under Means and under Reza is that there needs to be an express warning saying this is the last counsel, and also under Means is a real sense of saying these are the crucial issues that are involved in this case, the dangers of proceeding pro se.
Colloquy, in other words.
A colloquy of some sort. that-
Incident to the waiver of an important fundamental constitutional right.
I think that's our.
There was a
that's our argument,
colloquy
Judge.
in Reza. The need for colloquy for waiver by conduct was identified in Means and reiterated in Gibson.
That's correct, Judge. And I think one of the things that in my research and preparation for today that's not in our brief is that there are several unpublished decisions of this court, 23.0 decisions, that basically address this whole issue of what's required. There's Reza and there's Means and there's Gibson talking about what needs to be.
Gibson was published. When it was here, I authored the case and thought that the conduct was sufficiently egregious to warrant forfeiture, and the SJC took the case and illuminated for me the error of my views.
My apologies, Judge. I don't.
You don't need
I
to apologize on
that-
behalf of the Supreme Judicial Court. It goes with the territory. But it was an important recognition, it seems to me, of the fact that even though there may be a great deal of frustration and challenge associated with the progress of a case in the trial court, there are important constitutional safeguards that must be met before there is a finding of a waiver by conduct. There are to be specific procedural safeguards and underlying findings of fact and a colloquy.
And Judge, I think those are the points we wanted to make, that there's also the SJC Rule 310 and kind of a waiver of whether a party has knowingly, intelligently waived their right to counsel. And so the waiver by conduct is kind of
And there's a
akin to
distinction
that.
between forfeiture and waiver by conduct. But here we're talking about waiver by conduct.
That's correct, Judge. Forfeiture is a much more, I believe that was Gibson case. But the 23.0 unpublished cases are also Commonwealth versus Hullum, where there was an express warning to the client of the dangers of waiver of counsel, and that an appointment of one more counsel, but that if they weren't to work with that counsel, that they would have to be proceeding pro se. But a panel of this court nonetheless overturned that case because the colloquy of the dangers of proceeding pro se and the importance of the proceedings and so forth wasn't addressed to the client. There's also care and protection of Quinnell, adoption of Brianna, which we cite in our brief, In re Velma, and adoption of Igor, all talk about the roles and the interchange between having counsel, having standby counsel, proceeding pro se, and all of those issues, which I would submit to the court that it seems like that these are crucial issues facing the juvenile and probate courts currently. In addition, in Velma, there's a footnote that basically says that even if the court, which I think in this case was kind of citing that there was a shortage of attorneys and that we can't, and not an endless supply of attorneys, that should not be considered. And that's a footnote in Velma that talks about that issue as well and says that should not, while that may be an issue, it shouldn't equate and impinge upon the fundamental constitutional right of somebody's right to counsel.
So what is it that a trial judge faced with this situation is supposed to do, not just in terms of administering an appropriate colloquy, but as a practical matter? This case must move forward, right? Faced with
Absolutely,
a
Judge.
serial dismissal of counsel, at some point, there needs to be an appropriate adjudication.
And I think somewhere in the line of the cases, in Reza, the trial court, I think the opinion said, demonstrated extreme patience with Mother in terms of appointing several counsel, even after the express warning and the colloquy about the dangers of waiver, appointed 3 more counsel before they finally decided, or the judge decided that Mother had waived her right to counsel through conduct. And I think somewhere in terms of those lines, I would submit is that the test under Means and under Reza is at least that there's the colloquy, there's the understanding that counsel is being appointed, but that this is the last counsel, or to your point, Justice Ditkoff's point of I'm giving you one more counsel, but there's not really an attempt to talk about the dangers of proceeding pro se, that this is the last attorney that you will get. I don't think that warning was given in this case, which is what Means and Reza would indicate. And again, going back to, I think in the Brianna unpublished decision, there is an acknowledgement that appointment of standby counsel is not the same as the appointment of counsel. And sometimes there's also issues in all of these cases. If you look through the records of them, standby counsel sometimes is allowed to conduct voir dire, make objections, file motions in limine, and do so forth. And in other cases, as in this case, standby counsel was limited to just assisting mother in terms of documents, but could not really do anything, file motions or anything else on behalf of mother. And so that's quite the different issue. And I think just pivoting to our second argument is the nexus of the failure to show that the issues shown was there was no harm to the child. I think that some of the issues, mother having counsel, would have been able to address some of those issues. Some of the evidence that's in the record certainly would have, I would submit, under adoption of Luke, would not be able to come into evidence because counsel would have filed motions in limine, would not have allowed that evidence to come in, some of the basis for the finding of unfitness. I think the rest of the findings, or the rest of that argument, I think are in our brief in terms of the timeline, in terms of
Let me ask you this. I assume I know your answer, but I'd like your reasoning. The judge doesn't warn the mother about the dangers of representing herself, but she seems to understand them anyhow from this record. Why doesn't that make a difference?
Well, I suppose that's a good question. I would submit that under Means and under Reza that it's not. I don't think the court can kind of be guessing at what the understanding is, but there in fact needs to be some sort of whether it's an official colloquy and a waiver, the way that SJC Rule 310 would be, and in terms of knowing intelligent waiver of counsel, or whether it's some sort of questioning with regard to make sure that the parent or the client definitively understands the rights that they're giving up and the dangers of proceeding pro se. But I don't think it's left to kind of looking at it either afterwards or by implication of whether or not the person's truly understanding the rights that they're giving up. I
think we'll have to leave it there.
I'm sorry.
And we have Child's counsel that's asked to address us for 3 minutes. Child has filed in this case as appellee, but is appearing in support of the mother's arguments, as I understand it.
Yes, thank you. Myrna Diaz on behalf of the child. May it please the court. Your Honors, the child is now 16 years old. He is a sophomore in high school. He is still residing with his father, and most recently expressed that he still wanted to return back to living with his mother. Throughout the case, that is what I advocated for on his behalf. Even present
Can you
during.
just say the child?
Oh, the child.
Yeah, pretty much in every single one of these cases where the attorneys don't say child in the brief, the attorneys say the name. So it'd be really great if you all just stopped and just said child every single time, even in the brief, it's child.
Thank you.
You're in good company, but child.
Thank you, Your Honor. So the child did appear, and he was willing to testify in order to let the court know his position regarding wanting to return home with his mother. Unfortunately, he became very overwhelmed, and he ended up leaving in the middle during the break during that day of the trial. After the trial and after the judgment, which is, I did not get to file a notice of appeal timely, was because at one point he had said he did not want me to move forward with filing an appeal, and then later on told me that he did. And at that point, I just felt it was best to proceed as I did. But most recently—
So, I mean, I want to be clear. I don't think that anything hinged on whether he testified. It seems like his position was made very clear to the court. But what I don't see addressed is a concern that whatever was happening with mother, there was a lot of disruption in his life. I think it was 6 different schools and an insistence to a medical exam that he did not want and did not say was, and said was not appropriate.
Yes, and I was able to meet with the child from the very beginning of this case back in July 2021 and onward. And from the onset, he did not ever expressed that he felt unsafe at home or that he wasn't well taken care of at home. Obviously addressed all of the issues that were being presented as to why he was removed, and he never expressed that any of those things that were being alleged were concerning to him or bothered him in any way. He seemed to have a very strong relationship with his mother, and was very respectful, very well-spoken, articulate child, and he never expressed that any of the things that were going on at home were of concern to him. And this is through many, many conversations.
Counselor, I feel like, and I'm going to take you past your 3 minutes, I feel like I'm missing something. Because even if we reversed, and even if on remand the mother was found to be fit, we'd still be in a 209C situation where a probate judge would have to decide the best interests.
That is correct.
So I'm not missing that.
You're not, and that's something that I, as child counsel, cannot move forward with filing on his behalf.
Would he get counsel? Would the child get counsel in a 209C at this age? I don't know how that works.
So he would be able to get ARC counsel. So just an attorney that would be appointed, and those attorneys work pro bono. I would obviously be able to ask CPCS if I could extend my representation of him to the 209C, but I'm not sure if that would be possible.
All right, that's really helpful. Thank you.
Thank you.
Thank you. I have nothing further. Thank you.
So we will have counsel for the father.
Yes, sir. Good morning. May it please the court, my name is Julia Healy, and I represent the appellee father in this matter who has custody of the child. The court did not deny Ms. L's right to counsel as she waived that right by conduct. As your honors know, the right to counsel is not absolute. A party can waive their right to counsel by conduct when they engage in misconduct after being warned by the court that such behavior will result in the right to counsel. Turning to Justice Ditkoff's concerns about the colloquy, in this case, on February 10th, as we've talked about, there was an express warning by the court that she would be given one more lawyer.
That sounds to be a warning, not a colloquy.
Your Honor, I would argue that
And there's some question when you compare it to the other cases about the clarity and forcefulness even of that warning.
Your Honor, thank you. I would argue that there were 3. I'm going to use the word colloquy. It's not, as you know, a criminal colloquy on a plea. It's a different type of colloquy.
No, but it's a colloquy that for these purposes is the equivalent of what would be expected in a criminal matter where the waiver in question is a waiver of the right to counsel.
Yes, sir. It's a waiver of whether mother understood her right to counsel.
And as Justice Ditkoff has observed, the purpose of that colloquy is to ensure that any waiver is knowing and voluntary. And as part of that, it involves a description in rather significant detail of all of the ramifications and implications, all of the rights, all of the safeguards that will be lost if that waiver goes forward. Where in the record did that take place in this case?
Your Honor, I would akin this case to adoption of RESA, in which...
In RESA, there was a full colloquy, and so my question is, where in the record of this case is there an indication that the full colloquy describing the ramifications and the nature of the rights that were being lost, where did that take place?
I'm going to answer in two parts, if I may, Your Honor. Number one, I can point to the dates and tell you what the colloquy said, but number two, I can also say that she clearly understood the danger of proceeding pro se, given her actions after she had standby counsel and then actually asked for that standby counsel to withdraw.
So let's start with the occasion that you contend satisfied the requirements for a colloquy supporting a knowing and voluntary waiver, and we can examine whether the scope of that colloquy was adequate.
So I would say, Your Honor, we need to look at it in totality. So there were three different dates, November of 2021 being the first. When she was appointed her third attorney, the court said that they had limited attorneys, so Ms. L needed to work with those attorneys. On February 10th,
That's a warning. That's not a description as I heard it, unless there's more in that transcript that you want to point me to.
there's not more on that particular date.
Okay.
There is on February 10th of 2022, where the court said that they would only appoint one more attorney. They did not have an endless supply of attorneys. She was not entitled to continuous attorneys. And I believe this is important. She needed to work with her attorney so she could have legal representation from someone trained in this very specialized area of law.
Okay, and where in that exchange is a description of the significance of the rights that are at risk of being lost, and a warning about the potential ramifications and adverse consequences?
Again, I think that's where we need to turn to part two of my answer, if I may, Your Honor.
I'm just asking for where the colloquy took place, because we can talk about sort of a broader, ephemeral totality of the circumstances theory at some point, but I want to make sure that before we turn to that I have a full understanding of the areas in the record of this case where a full description satisfying the requirements of a waiver of counsel took place, because I want to make sure that I'm not missing something.
And I appreciate that, Your Honor. That is what happened on February 10th of 2022.
Okay, and so where is it that, what page? I'm at page 261?
58?
Don't have the transcript.
258 is what she was reading from.
Yeah.
And then if you turn to March of 22, when the court appointed this, when Ms. L asked for her standby counsel to withdraw, the court then said it was very hesitant to allow the withdrawal of standby counsel, but since Mother was insisting on it, the court was doing it, that a right to an attorney was not unending, that Mother had failed to work with her attorneys and then asked to dismiss them. The court saw that pattern and the court needed to stop that pattern. Now turning to the fact that she clearly understood the danger of representing herself. With her standby counsel only, she filed 64 motions, 5 appeals, and 2 interlocutories. Those show that she understood the nature of proceedings, how she wanted to proceed, and she knew how to proceed. Again, and the court, in RESA also the court said that the trial courts have broad discretion to take measures to keep cases moving forward. In this case, she had warned Mother 3 times. She had told Mother that they did not want to withdraw the standby counsel. Mother insisted on withdrawing the standby counsel. It was the day of trial. Mother knew of the trial date for 3 months, yet waited to ask for standby counsel.
Counsel, couldn't you take the opposite, which is because the mother filed so many motions and seemingly motions, some without merit, and the numerous appeals, rather than follow a more usual appellate process, that she didn't understand?
I would argue that she did, Your Honor. The motions, I believe, I don't have all of them off the top of my head, but were motions for her child to be returned, were motions on point. So,
Doesn't it seem like she had an unrealistic view of what she could do pro se? Of how easy it would be to proceed pro se?
I believe that she, in her mind, had motions that she wanted to be filed. Some of them were filed. With counsel, she filed 18 motions, but I believe that some of these motions, the court even alluded that some of these motions counsel would not be able to file, and that she was she wanted to file these motions, and she was going to do it
The
without a
challenge
lawyer.
here is that it may well be that at the end of an appropriate process, we would have reached the same result. But those procedural safeguards are in place for a reason. And compared to the colloquy that's described in the report of the decision in RESA, I don't see anything in this record that satisfies, and the same is true, you don't address, and the department doesn't address Gibson in their brief. And I understand that Gibson was a forfeiture case, but the SJC went on to address the question of waiver by conduct in that case as well.
I don't know if it's a question, Your Honor, of whether the same decision would have been reached. I think it was a question of she had been through 4 lawyers and a standby counsel. It was the trial date.
In RESA, there were 8 or 9, and Gibson, there were 9. I mean, these things can go on for quite some time, and whether 4 is enough or not is really beside the point, because if the judge had conducted a full colloquy, had made findings, had inquired into the, as means requires, the least intrusive available alternative, we might be in a different situation. But this is troubling.
If I may answer your question quickly.
Please,
see
I
I'm
know
out of
that the
town.
red light is flashing, but that's my fault.
Thank you, Your Honor. I would say, Your Honor, I'm sorry, I briefly lost my train of thought. I would say that the court, it clearly says in RESA that moving the case forward is up to the trial court's discretion. They had already put off a pretrial date because she had asked for another counsel, and the judge had allowed the counsel time to get up to speed. We had 3 other lawyers who needed to get up to speed. She had not asked for a lawyer before the trial date. At this point, it is now the trial date. She is on her 4th lawyer plus a standby counsel, and RESA makes it very clear that the court has broad discretion to look at the case, to look at her right to counsel, to look at the need to move the court forward, to look at her acts with counsel. She'd been willing to unwork with any counsel. She dismissed them within a matter of weeks or days. She'd filed CPCS complaints against them. That was in the trial judge's discretion at that point to ask her to proceed pro se.
All right. I think we can leave it there and hear from the department. Thank you.
Your Honor.
Good morning, Your Honors. May it please the Court. Lynn Murphy for the Department of Children and Families. The trial court did not err in finding that the mother had waived her right to counsel by her conduct. As my sister has pointed out, the court gave numerous warnings to mother, and those warnings escalated as time went by. So we went from the court
But couldn't they have
explaining.
been a little more clear, like, this is it, you're not getting another attorney?
I don't see how the court could have been more clear, because in February 2022, the court said, I will not appoint you a 5th attorney, and the court reiterated that again the next month. So the court was very clear.
But when the court gave that warning, it was not accompanied by an explanation of what that would mean.
I think the problem that we're looking at this case, there were ongoing discussions with mother throughout the filing of the CMP from day one.
Well, I can well understand the challenges faced by the trial judge and the frustration and the difficulties. These cases that's inherent in the cases that raise this question.
I wouldn't say that the judge was frustrated. I think the judge had an ongoing discussion with mother, and they discussed the rights that she was facing, the potential
Okay,
impact.
now I'll ask you the same question. When you say they discussed the rights that the mother would be facing, is there something more in the transcript than what we covered with the Father's Counsel?
Yes, I think if you look at again, Father's Counsel did point you to the most relevant February and March of 2022. However, if you look at the entirety of the transcript, there were numerous conversations between the judge and mom, and mother clearly understood.
Let me ask this question in a slightly different way. I described in an earlier exchange my view that the colloquy necessary for a knowing and voluntary waiver of counsel in this context is identical to that in the criminal setting. Do you disagree with that?
I don't disagree that a specific colloquy would have been preferred.
Well, no,
than
a specific colloquy is required. The question is, what is the scope of that colloquy in order for it to be adequate?
Yeah,
and my operating premise, which I believe to be correct, is that in order to be adequate, to support a knowing and voluntary waiver of the right to counsel, a colloquy for a child welfare case must be the same as a colloquy for the waiver of counsel in a criminal matter.
As long as the individual knows what their rights are and what is at stake, I would say that that was met. I think that was met here because mother clearly understood. And again, having a specific colloquy would have been preferred, but an ongoing discussion about her rights and what was taking place and what would take place in that courtroom is
What is the
sufficient.
case that you can point us to that contains a colloquy of comparable scope to the colloquy in this case, where it was held adequate to support a waiver of counsel?
I think the facts of this case are quite unique given the circumstances, and I would not be able to point to a case where the circumstances were identical.
I'm not talking about identical. I just said closest.
Other than those cited.
I mean, there are a fair number of these cases that are out there, and each case is unique. And most cases proceed without raising a question of waiver of counsel by conduct. But there are enough of them out there. And I'm not familiar with any that has included a colloquy like this that was found to be knowing and voluntary.
I do not know any care and protection cases.
Counselor,
A criminal case would be fine too, because we've established, I think, sufficiently that a waiver of counsel in a criminal context would raise the same requirements. And so if there was a sparse colloquy in a criminal matter that was held sufficient to support a waiver of counsel, I'm open to that as well.
Again, I know of no cases off the top of my head, but I would, again, submit that there was no misunderstanding by this mother of what
This issue was fully joined in the briefing. I mean, if you wanted to present a case, there was plenty of time for that.
I felt that the judge acted appropriately. I felt my case cited supports what the judge did here. And also, I would point out, remember, care and protection cases are very different from criminal cases. We have the rights of a child.
Counselor, can I ask you something about that? I'm not saying this is required, but in a criminal case, usually when you get to this point, the judge says something like, either you stick with this attorney or you go pro se. It's your choice. That's usually how it ends, and the defendant picks one of those two. Is there a reason why that doesn't seem to happen in DCF cases?
In DCF cases generally, or in this
Well, I mean,
particular case?
maybe that does happen generally. I got the impression that I got the impression from you this was common. Maybe it's not. That's why is there a reason why there wasn't the sort of, you either got Attorney Curtis or nothing, your call at the end here?
Well, again, because there were 4 motions to have Attorney Curtis removed, even after she was appointed as standby, we had this ongoing behavior by mother that the that the trial court judge tried to deal as productively as possible. And again, when you look at the totality of the discussions with mother, you can see the judge was struggling, trying to protect her rights, trying to give her an opportunity to have counsel. And mother simply did not want assistance of counsel. When you look at the situation, you can see, again, by mother's comments, repeated comments, she was not interested in having legal counsel or legal advice or representation. She preferred to represent herself, file her own motions, and present the case as she wanted to present it. And she can make that determination. And she did so in this case. And at one point, the court, the court needed to proceed for stability for the child. And I think the court acted absolutely appropriate given these circumstances that were present in this case. If there are no further questions, I will rest on my brief.
Seeing none, thank you. These cases are always difficult but well presented on all sides. Thank you. We will be in recess for 15 minutes. We will resume the session at 11 o'clock. All right.
Court all rise. Close the session, please be seated.
As previously indicated, we resume our session with the third of the three criminal matters, case number 2022 P925, the Commonwealth versus Marcus Gomez. Again, this case is partially impounded.
Good morning, Your Honors. Tara Ganguly for Marcos Gomez. I'll start with the first issue, the authentication issue of Exhibit 12. The WhatsApp messages and voicemails that were admitted in this case were not properly authenticated, where MT testified that she gave these WhatsApp messages and voicemails to Detective Chadbourne. Detective Chadbourne did not testify. Detective Tinkham testified ostensibly to what Detective Chadbourne did in taking them from her. I think it's important to note that even the prosecutor, the trial prosecutor, in submitting the evidence or asking the court to admit the evidence, marked the exhibit for ID during MT's testimony and then asked for it to be admitted during Detective or Officer Tinkham's testimony.
Your problem is that the officer did not say, I saw this other officer do this?
No, I think my argument goes more towards what MT did or did not testify to. I still think that the issue is properly preserved because there was an objection. The objection was made during Officer Tinkham's testimony, not during MT's testimony, but that's because it was during his testimony is when the exhibit was actually offered into evidence.
But the objection did not identify the concerns that you're now arguing on appeal. And one of the challenges about authentication or foundation is that deprived of a challenge at the time of trial, there's no need or occasion to supply the missing information. We don't know what, in other words, could have been supplied had the Commonwealth been put to the task of doing so.
I admit that the objection was not perfect. The objection was based on Tinkham's lack of personal knowledge about what happened, but I think personal knowledge, I don't know what personal knowledge actually means. I think it's related to the issue of, is this item what you claim it to be?
So ground adjacent is adequate to preserve a claim of error?
Yes, and I cited the McDonough case. Perfection is not the standard by which we measure the adequacy.
Well, I understand that, but particularly where we're looking at a concern that, for all we know, could easily have been remedied had it been raised at trial. One of the purposes of an objection is not simply a technical matter of preserving the claim for appellate review, but also allowing the trial to proceed in an orderly fashion.
Correct. I mean, if this court wants to take it on a substantial risk, I think the error is still there.
Well, how do we know that it was error when we don't know what could have been supplied?
Well, because a piece of evidence still has to be authentic for it to be admitted.
Right, correct. So let's go to the indicia of authenticity, because it seems to me that before we get to substantial risk, we have to find error. There were any number of details in the victim's description of the sequence of events that were uniquely known by this defendant. And their reference in the various text messages tends to suggest, therefore, that he would have been the author.
I think his text messages are not as clear as the Commonwealth wants them to be or says that they are. You know, they were translated from Spanish to English. There are a lot of things that he says that, in my mind, don't make perfect sense. And maybe that's just the translation.
But there's corroborating details consistent entirely with the account that the victim provided.
Not specific information. I mean, he talks about, you know, harming her and hurting her, but it's not specific as to exactly what she testified to at trial in terms of the specifics of what happened.
So your nails on my face, did you go to wash? If you've not gone, wait for me. Aren't those exactly what the victim testified
The
to?
victim's nickname that the defendant had for her, and wash, laundry, the whole role that the trip to the laundromat played in the sequence of events.
I don't think that simply what the content of the messages is enough. The cases talk about additional confirming circumstances. I think this case is closer to both Williams and Salyer than it is to Purdy and Gilliman and Alden, specifically with respect to these being WhatsApp messages and not traditional text messages from cell phone to cell phone number. I don't know if Your Honors are familiar with WhatsApp. There was certainly no evidence about what this app is, and I understand
I happen to
that
be
that's
familiar with it,
because-
but that knowledge resides outside of the record in
Exactly.
this case, and so to the extent that you're going to offer an argument about...
I'm not.
Okay.
I'm not.
Let's not go there.
My only point is that it is different than a traditional text message, and it's more similar to, no one uses MySpace anymore, but there are the cases about MySpace and
Facebook.
Facebook.
There are any number of other apps, but the question technology has carried us in lots of new directions, but to use a line from an old movie, the fundamental things apply. The whole question is whether we can identify indicia that suggests that this is what it purports to be.
Right, so I understand Your Honor is correctly focused on what the content of the message is, but in these other cases, they talk about, in Purdy and Gilman, the emails and Facebook messages were downloaded from the defendant's own hard drive. That didn't happen here. Here, the messages came from MT's phone.
But from her phone in a manner that identified the defendant as the sender in a context where they had been in regular communication. And she
didn't testify that they had been in regular communication.
No, the text messages showed that regular communication, again, assuming, of course, that they're authentic. I understand that. But the point is that she can easily describe and corroborate the character of the defendant's communication style, certain slang words that he routinely used in their private communications, and specific details that he included in the messages about the night in question. All of those were present.
She could have testified to, yes, she did mention the nickname, but additionally to that, she said, everybody calls me that. She could have testified to, yes, we always use WhatsApp, this is the way we communicate, we've used this for our entire relationship, and I understand defense trial counsel did not specifically raise the issue I'm raising now, but she still didn't testify as to, this is how we've always communicated, this is the way our communication continued after this event. And I could not find any specific...
Even if this were the only time they communicated through WhatsApp, but the content was, but she said that I thought this was from him and it described events that had happened, wouldn't that be enough? I mean, even if he'd never written her a letter,
I
but he
think that's the
suddenly wrote
same-
her a letter, I mean, there's no mystery to...
Well, the letter, she did testify that she recognized his handwriting. The jail, the phone calls from Middleton, she testified that she recognized his voice. With respect specifically to the WhatsApp written messages and voicemails, she didn't testify to any of that. She didn't testify to, yes, this is how he talks to me, yes, this is his voicemail on these WhatsApp voicemails. She didn't testify to that. I'll move to the second argument unless there are any further questions about authentication. So assuming the court does believe that these were properly admitted, I still don't think that there was sufficient evidence of witness intimidation in this case because the essence of the witness intimidation statute is about fear, force, threat of force, bribery, misleading, intimidation.
Or harassment.
Or harassment. these statements, the defendant's statements to her, were pleading, polite to a certain extent. I understand the history of in domestic violence cases, there is a sense that a victim is most likely always in fear. I understand that. But at some point...
Well, and when the request, however politely phrased, is cast in terms that suggest dire consequences for the person making the request, it leaves unspoken the question,
Correct. I didn't see anything...
what will happen if I don't comply?
Absolutely. I did
In
not...
the context of this relationship and the history of violence perpetrated by the defendant against the victim, giving rise to a restraining order, why is it inappropriate for a rational jury to infer that the victim would have felt fear for the potential for violence if she didn't comply with the defendant's requests, even if they did not contain an explicit threat?
I think my opposition to that would have to be...
Well, you don't want to frame your answer in terms of opposing me. I'm just looking for an answer.
You can oppose them, it's okay.
Well, I think there has to be a case. If it's not this case, there's going to be some case eventually where communication between a defendant and his victim at some point after an incident, even if there is discussion about, are you going to go to court? Are you sure you want to go to court? I understand there's a litany of cases. Yes, that's automatically witness intimidation. I don't see why it has to be such an automatic conclusion.
It doesn't, but it does allow for a jury to draw reasonable inferences from the facts taken as a whole, including the entire context and history of the relationship between the parties. And in this context, as the Commonwealth argues, it doesn't take a great leap of the imagination to imagine the victim being placed in fear of what will happen if she doesn't comply with the defendant's request, even in the absence of an explicit threat of violence. But setting that aside for the moment, Justice Ditkoff reminded you, after you described the predicate for intimidation, of the second prong of, relating to harassment. The nature, frequency, variety, and timing of the many, many, many communications in which the defendant made this request. How does that not satisfy a fair definition of harassment? And by the way, in the context where there was an outstanding harassment order, anti-harassment order.
The way that she answered the calls with the three-way calling with the jail calls, and he had someone else call her, the way that they spoke was very casual. Oh, how are you doing? I'm fine. What have you been doing? Nothing, it wasn't, don't stop calling me, please stop calling me. It was none of that.
I thought she hung up the first one.
She may have hung up the first one, but she certainly answered at least the second one. If there are no further questions, I'll rest on my brief.
Seeing none, thank you.
Thank you.
For the Commonwealth?
Thank you. May it please the Court, Emily Mello on behalf of the Commonwealth. I'll begin with the first issue with respect to the authentication of the WhatsApp messages. As an initial matter, the issue is waived. MT here identified the text messages, and she identified the disk containing the voicemails, and then Detective Tinkham authenticated the translation. There was a translation here because English is the language of the courts, and so that Exhibit 12, that English translation, is what was actually admitted. The objection here was not to the authenticity of the messages as being from the defendant. The objection here was to Detective Tinkham lack of personal knowledge about what Detective Chadbourne had done. And what he actually, the defense counsel said in the objection is lack of personal knowledge. Detective Tinkham doesn't know whether or not Detective Chadbourne did. And what I'm doing this is mostly because the court denied my request for a continuance and offered this in the alternative. And then he makes that same objection again, basically every single time that Detective Tinkham testifies about something that Detective Chadbourne did. This entire objection was geared towards the fact that he wanted a continuance to have Detective Chadbourne testify rather than Detective Tinkham. It had nothing to do with the authentic.
Did Detective Tinkham ever say, I know exactly what the other detective did because I was watching him? I mean, like, how did he provide personal knowledge?
Well, first, I would say that's not raised on appeal. And second, what's raised on appeal is the authenticity of the WhatsApp messages. And second, I would say that Detective Tinkham was able to testify about what his colleague did in this case because he knew what his colleague had done in this case. And again, that was not raised, that isn't raised on appeal.
It's kind of mystifying, though. The victim testifies, these are the text messages. So I don't understand why they don't get admitted then, having just been identified by the witness. And I really...
They're in Spanish. So they can't, when something...
There's a translation. She doesn't know the translation?
Only the translation is admissible. So that's the reason, I know, it's a little bit confusing, and I tried to lay it out in my brief. The reason it was done this way is because the messages are in Spanish. English is the language of the court. Only the English language translations are admissible. The jury doesn't get to see the Spanish.
Are we wrong about that? I mean, should other languages be able to come in with the translation?
Again, not raised in this case, and that's an interesting issue. Not raised here, so I don't really have an opinion on that specifically. I think that the reason it's done in this particular way is because the courts want just that translation to be the evidence on the off chance that there is someone who speaks that particular language and they have a different thought. Not raised in this case, I can't really give an opinion. What I can give an opinion on is the fact that the victim here testified that these one, the issue is waived. Two, the victim testified that they were messages from the defendant without objection. And thus they were properly authenticated. And in any event, I think the cases suggest, Oppenheim, Welch, Gonsalves, the fact that this extensive conversation about contemporaneous events, about what's going on in their lives, would have been awfully difficult to fabricate.
So this thing in your supplemental appendix with all the Spanish redacted, that's what the jury saw?
So what the jury saw is exhibits 12, 13, 14, and 15, which are identified in the supplemental record appendix. I have also included there what was identified as IDE. So the victim, she identified the package of WhatsApp screenshots, which I have there in the supplemental record appendix, as it was identified in court, as the messages from the defendant via WhatsApp. She also identified a CD that contained the Spanish audio of voice messages that were left. That was identified as IDF. So because that's in Spanish and that is not admissible in court, then Detective Tinkham testifies regarding the translation, and that translation only is admitted as Exhibit 12. So that's the procedure when something is in a different language. But in any event, that's not at issue here at all.
It's really interesting, though.
It is really interesting.
I mean, it also assumes that when people are speaking English, we understand them. I mean, we often come up with cases where youth in particular use words in ways that older people might not understand, but if the prosecution doesn't put in a translator from English to English, you know, I mean, they like to use words the opposite, you know, oh, that's sick, right? To a large number of people, that would be not good. But to youth, it's really awesome. I could give you 50 examples where.
Sure, there's a million examples, and, you know, sometimes, this is totally off topic, but, you know, in drug cases, sometimes you'll have someone testify as to vernacular, et cetera. But in any event, in this case, the victim testified that these WhatsApp messages were from the defendant, that the voice messages were from the defendant, and the context of them confirmed that they were from the defendant, and also the defense was not that these messages weren't from the defendant. The cross-examination and the closing argument all suggest that the defense agrees that these messages are from the defendant. He's saying, well, you picked and chose what messages you showed to the detective, et cetera. He's not saying these messages aren't from the defendant. They were.
Do the messages, particularly the ones that where she said, I recognize his voice, or did they sort of also contribute to authenticating the WhatsApp messages? In other words, was the content very similar?
I think the content is similar, but I think regardless of exhibits 13, 14, and 15, the WhatsApp messages were 100% properly authenticated in this case, and in any event, the issue wasn't raised. So the Commonwealth wasn't even put on notice to say, well, this is, I know because of X, Y, Z. She said these messages are from the defendant, and there was no objection. And the context confirmed that. If there are no further questions with respect to that issue, I'd like to move on to the witness intimidation issue. There was certainly sufficient evidence here for witness intimidation under two theories, under either the intimidation theory or the harassment theory. I think that this case is ruled sort of in all aspects by Gardner. It's very similar with respect to the ongoing context of a domestic violence relationship and everything that he is saying to her in these calls and the letter. And I just want to go through a couple of the things that he said. And then also, even in the WhatsApp messages, he tells her that he'll be prepared if the police come to arrest him, asks her not to affect him on that side. After his arrest, he calls her, he asks for her position, whether she'll make things easier for him. He says that she could be of great help, that he would be thankful. He says his children would be thankful. He plays on the sympathy that has been the context of this entire relationship. The sympathy and the, oh, I love you, versus the everything you're doing is wrong, and the abuse and the harassment of her. He says that the prisoners lynched him. They broke his arm, they broke his head, they broke his ribs. He's only given bread and ham with a glass of water. He begs her not to make his crime more serious by reporting the letter, because that would be another charge. He asks her to soften her heart and not accuse him anymore. Just leave him alone in the courts so they'll dismiss the case. He begs her to ignore the courts so that he would be able to leave jail one day. And then I think most poignantly, in the context of all of that, he tells her that if she gives him the opportunity to live a life outside these bars, he will not bother her again, and he will let her make her life as she wants, as if he has control over how she lives her life. That is harassment, and that is intimidation. If there are no further questions, I would rest on my brief.
Thank you. Thank you both.
Thank you.
The next matter we have on for hearing is case number 2023 P770 in the matter of the estate of William F. McLoughlin Sr. Me.
Okay, thank you, Your Honor. Good morning. My name is Barry Backrack, and I'm here on behalf of appellant Sean McLoughlin. Here, the probate court misapplied a, quote, non-contest provision, close quote, and granted summary judgment against appellant disinheriting him. We assert, of course, that the trial judge erroneously construed that clause. The critical error I believe the trial judge made is it did not refer to the authorizing statute as to what would be allowed as a penalty clause. So I refer the court to...
So are you arguing that the statute displaces the prior law?
I'm arguing that the statute was enacted and it states, yes, it states what is enforceable, to the extent that it defines what's enforceable, it's a penalty and it has to be construed narrowly. So I believe that the statute is clear that...
Before we get to your explanation on the statute itself, I just want to, because I have a similar curiosity, I think, to what Judge Henry is asking. If we look at the provision itself, as it would have been considered under the common law of Massachusetts before the enactment of the statute, would, in your view, would the provision warrant the invalidation of Sean's interests under the will?
No.
Okay, so let's talk about that first, because maybe we don't need to worry about the statute.
Okay.
Because you're saying that the statute plays a role in limiting the scope of enforceability, but you're also arguing, if I understand your last response, that it doesn't matter in this case because even if we take this provision with the absence of any statutory limitation, the provision isn't implicated by what Sean did here.
Right. If I look just at the statute and construe it narrowly, it says, first, if any beneficiary hereunder shall contest the probate or validity of this will. And there was no will contest. This will was allowed without objection and admitted to probate.
Wasn't there a motion seeking leave to file an objection outside of time?
Correct, Your Honor. That was filed after the will was admitted to probate.
By a different brother?
I understand.
Yes, by a disinherited brother, correct.
All right.
You don't think that was contesting the validity of the will? I mean, regardless of whether your client was doing it.
Regardless, if my client, regardless of my client, yes, the disinheriting brother filed a motion to seek leave to contest the will. And so he sought permission to file a will contest. I think it would probably be form over substance to say he wasn't trying to contest the will.
Right. And then Sean, your client, filed an affidavit citing grounds on which the will could be declared invalid.
Well, Your Honor, number one, I think it's immaterial, but my client, Sean didn't file it. The disinheriting brother's attorney filed it. That's at A13 in the affidavit of Sean, that he was approached by the disinheriting brother's attorney because of the facts set forth in the personal representation. And in response to that, he gave them an affidavit, which they made a supplemental filing. He didn't file it personally. He was really a provider of facts.
Why is his remedy not against that attorney? Because he said this isn't going to bite me in the behind. That attorney should have referred him out to another attorney to look at this, if I have your question right, Your Honor. But unfortunately, he didn't, and there was, but it's one of those situations where my client could have been, they could have deposed him, or...
Yeah, I want to be clear on just exactly where we are at this juncture procedurally when all of this is taking place. So the disinherited brother has filed a motion seeking leave to late file an objection.
Correct.
Had that been acted on?
No.
Okay. So that is pending, and his attorney, in support of that request, presumably to persuade the judge that there is something that's worthy of consideration in deciding, in the interest of justice, whether to reopen the question, reaches out to your client and asks for factual substantiation, which he then files.
Right, Your Honor. The only thing I'd insert there, because I think it's important, is that the personal representative provided an opposition to the motion to file late. And in that opposition, he claimed certain key facts that the disinherited brother should have known about the will of certain conversations in front of Sean. That was paragraph 15 of that affidavit. It was after that that the disinherited brother's attorney approached Sean and asked questions about that, and additionally put in facts about competence and undue influence. But the key thing for that affidavit, and Sean got involved, is because his name was brought up by the personal representative, not by the disinheriting brother. And there, he was more like, if you look at the language of the no contest provision, it says, shall institute or join in parentheses, except as a party defendant.
Let me just imagine, and I don't want to go too far afield, so let's not spend too much time on this, but suppose there had been an evidentiary, suppose the trial judge, having received the request for leave and the opposition to that request, but without an affidavit from Sean, had said, I think I really ought to hold an evidentiary hearing before ruling on this motion. You know where I'm going with this.
Yeah.
And at that evidentiary hearing, one or both parties call Sean as a witness.
Correct.
Would that be different from what we have here?
No, because he's providing facts at the request of one party that are relevant, are allegedly relevant to that party's motion.
And he would be under oath and obliged to testify truthfully.
Correct, Your Honor.
Just as he is under the affidavit sworn under the pains and penalties of perjury.
Correct, Your Honor.
I want to make sure you two are done. I don't want to step on your, okay. So if we agree with you that he didn't institute or join in a will contest, what about the first clause, or the first phrase in this interim clause where it says, if any beneficiary hereunder shall contest the validity of my will or any provision thereof? Are you saying that has to be a formal proceeding? It's not enough for him to say, I don't think the will's valid?
Yes, Your Honor.
So you're saying the whole thing, you have to have, he has to be a party not on the defense side?
Correct.
Okay.
And Your Honor, in connection with that, I think the other, just I'll mention while you're here, is that the judge's error in that is she looked at contest and said it could be either a formal proceeding or it could be something outside of litigation. Now, she was obligated to construe this narrowly. So where there were two possible choices, she should have taken the narrow one and ruled that it had to be a formal will contest and not generally contesting.
So you say she has to have construed it narrowly, and that's because of the statute?
That's because of even the common law. It's a penalty.
Okay.
And
what's your best case on the common law?
I'm sorry, Your Honor, I cited in the brief that you have to construe these narrowly. I'm sorry, I'm not remembering the case itself.
Okay, that's fine. We've got your brief.
Savage.
And, Your Honors, did you want to go to the statute at this point, or?
It's your time.
Okay.
Since I diverted you from that, I would not be offended if you wanted to return to where you began.
I mean, because if you look at the statute, it's section 2517, and entitled penalty clause for contest. And as your honors know, in Massachusetts is in the vast minority of states that allow for penalty clauses. And therefore, it's our position that this statute defines what can be an enforceable no-contest provision. And if you read the language, it says a provision in a will purporting to penalize an interested person for contesting the will or instituting other proceedings. And that's, the other proceedings is key because that gives, that means that the first contesting the will has to be a proceeding. So under the statute.
I thought the judge found your client contested the will.
She found he contested the will because he joined in.
And the statute allows that, a clause penalizing for contesting a will, right?
Well, contesting the will, it's a formal, contesting the will there is referring to a formal will contest where you file your notice of appearance and objection. In this case, the disinherited brother, after the will had already been allowed without objection, sought to file the motion to file an objection late. And that's where that issue comes up. But as far as contesting the will, no one contested the will. There's really no will contest here because the will was allowed without contest and the motion to object late was disallowed.
So what penalties, in your view, does this statute implicitly forbid?
What does it forbid?
Yeah.
It forbids a party from filing a formal will.
No. I mean, you seem to be reading this as saying that there are certain penalty clauses in a will that aren't enforceable.
Well, I think the way the trial court construed this clause, it wouldn't be enforceable. Because
so you plainly think that this statute makes certain kinds of penalties in a will unenforceable, and I want to know what those penalties are that are unenforceable. I mean, presumably, if there was you're disinherited if you're an addict, this wouldn't affect that, right?
Right.
So why does it allow that penalty and not a penalty for contesting a will other than by filing an objection?
I'm a little unclear about your last question, and I may have said yes too quickly. You said a will that disallowed.
It penalizes someone, says no one inherits if you're an addict. I've seen those clauses in wills. Penalty for being a drug addict.
But that's
there used to be penalties for marrying non-Protestants. But
this is a very specific. I understand. This is a very specific. You're right. There can be. I think there can be a whole universe of other issues that someone can say penalty. But with respect to contesting the will, and again, that's a very formal term. Contesting the will. Again, you file the notice of appearance and objection. And that's a formal proceeding. And then, what I'm saying is that this statute is directed at that type of conduct. It doesn't want, it's the intention of the testator that the will not be contested or objected to formally or in another proceeding, because you can collaterally attack.
But you're saying that even if we restrict this provision to just a formal court proceeding, that it doesn't qualify here because the will had been accepted and this was a late filed motion to basically challenge the will.
And I think you have to look at it.
Is that right?
Right. And look at carefully the facts here, where it might have been a different situation if Sean joined in and actually filed the motion, joined in as a party except as a defendant to file that motion. But here he was brought in as a witness and was providing facts. And someone shouldn't be penalized if they're asked to provide facts under oath.
And so you're saying even if the disinherited brother's motion was a will contest, Sean still can't be disqualified?
Not in these facts. I could envision possibly different facts, but these facts are very clear. I'm sorry, Your Honor.
I think we have it.
Okay, thank you, Your Honor.
Good morning, Your Honors. Maureen Curran on behalf of the three sisters, Margaret McLoughlin, Erin McLoughlin, and Susan Jewers.
Ms. Curran, before we get too far along, well, you've been listening. I figure you probably have a few things that you recognize we'll want to talk to you about. When I start, I guess my curiosity is whether, in your view, the statute modified or limited the common law that had been in place, or whether it was designed simply to codify existing common law.
I believe it was enacted to codify, Your Honor, and so, and people continue to cite Old Colony in all of those cases because they're still valid law. I haven't seen any cases that
So, in other words, there are, in your view, the statute was not designed to describe a category of interorum clauses that would be henceforth invalid, that would have been enforceable under prior common law.
Correct.
Okay.
Correct.
Thank you. I think that's my view as well, but I want to make sure that we shared that view.
I want to understand how broad you think this clause is. If Sean had stood out here in the Boston Common and yelled, "My father's will was not valid," would that violate this?
It may have if he gave statements, I suppose, that would make its way into the court, but I think
What
in
if he
this...
just read what he wrote, what the attorney wrote that he signed in the affidavit, but he just did it out here on the street corner?
If he did it out on the courts and no one was, it didn't have any effect on the allowance of this will, that might be, somewhat different.
Let's go back to the scenario that I described in my earlier question about the judge electing to hold an evidentiary hearing on the motion to allow a late filed objection, and without the affidavit. Now we're at a hearing, and Sean is called as a witness, and he's asked a question. He responds to that question and expresses his belief that his mother was subject to undue influence.
Father, right. Your Honor, and we actually talked about that at the hearing, that when they raised this argument that, this was just as though he was called, he was subpoenaed to a deposition, is how it was phrased in our argument.
For the moment, I'm not resting on the question of whether he was compelled under court order by a subpoena. Maybe he agreed on request.
I think that there's a difference, Your Honor, between
You think it
those
makes a
two
difference?
Because
Tell
if
me
you're
why.
compelled to do something, because a subpoena has been issued and you're brought to court and said, now you have to testify, that's different than voluntarily signing an affidavit that questions and tries to
Let's step away from the affidavit. Let's just look at the evidentiary hearing and the request that he appear and testify in court. So you say that if he says, no, I won't do that, you have to get a subpoena if you're going to make me testify, and they get a subpoena and then he comes in and offers the same testimony. That's okay. But saying, okay, I will, I'm not going to put you through the effort of getting a subpoena, even though I would be hard-pressed to identify any grounds on which someone could resist the issuance of such a subpoena. It seems kind of silly, doesn't it?
Well, right. I mean, I think that that once you're called via a subpoena, either for a deposition or an evidentiary hearing, you're being compelled. This is very different. What he says, I think we also have to...
What if you're not compelled? What if you show up to court voluntarily and as someone calls you and you decide to testify, no subpoena, nothing made you come there.
So I think if we go back to this very broad interim clause that the dad had stated, and I think that that's another important point here, Your Honor. This particular interim clause was pretty broad. And I think as Justice Henry pointed out, that phrase in it at the bottom that says, or prevent any provision thereof from being carried out in accordance with its terms.
That's a good question. So any provision, right? And one of the provisions of this will is that Sean inherits certain property, right?
Correct.
And your clients have now joined in a proceeding to invalidate that provision. So why aren't they forfeiting their inheritance under this provision as you're interpreting it?
Because they are trying to enforce the will in its entirety. They're not trying to say that.
Well, so it says any clause, as long as you have one provision and not another provision, you're not falling under it?
Right, and I understand where you're going with this, Your Honor, but that would negate the father's wishes that nobody try to invalidate his will.
But
And
you're
I think that we
invalidating,
have
he wanted Sean to get this property, and your clients are trying to stop that, and his intention was to disinherit anyone who tried to stop his will, his desire, I should say.
Right, so.
And aren't your clients doing that?
And what I would say to that, Your Honor, is he wanted Sean to get this will unless, because that's the whole point, is that Sean, you'll get this piece of property as long as you don't contest my will. Here, Sean tried to prevent the whole will from being allowed. And so therefore, the interim clause comes into place.
So the part where it says any provision, we disregard that? It's only the whole will?
I think you have to look at the totality at that point and say, what was Dad's intention here? And if you go by that scenario, I think interim clauses would just sort of disappear because no one could then invoke them. So, it would be, nobody would be able to enforce an interim clause. I'd like to point out, Your Honor, that in the appellant's brief, he throws in words that are sort of not in the statute.
I still want to go to my example where he just stands out on the street corner, or he just says to anybody, I don't think this will was valid. Is that covered by this?
If it would prevent the will from going forward, I think that's.
What he didn't prevent the will from going forward.
Pardon?
What he actually didn't prevent the will from going forward.
What he was doing was attempting to prevent this will from going forward.
What you're doing, it seems to me, is imbuing purpose and objective to an affirmative effort on Sean's part.
Correct.
When, in fact, as I understand things, he simply responded to a request that he offer his version of events.
And what he says is he asked to, the only reason he came forward was to question the statements of the personal representative regarding him. He makes a big deal about the fact that my name wasn't mentioned in William's affidavit. It was only mentioned in Tom's affidavit, who's the personal representative. And so if he had limited his affidavit to those couple of paragraphs, I think it's 15 to 18. If you look at paragraphs 15 to 18 of Sean's affidavit, those are about statements that happened after death and whether or not people were aware that there was this other will. That's a whole different story. If that's the affidavit he gave, then he wasn't trying to overturn anything. He was just.
We're trying to figure out, here you have somebody, I don't know how much their grieving was happening here, or how much time elapsed between the death and whatever, but he does, unless they file something or join as a party, but they are telling their truth, I mean, I just don't see that it's a good idea for the courts to say people cannot speak their truth, right? I get you have a different truth, but he's speaking what his truth is, and courts, that we cannot be taking the position you can't do that. So if this is why I keep saying, if he's standing on the street corner, but he doesn't actually file a will contest, what's the injury to the decedent?
The injury to the decedent is the decedent wanted to make sure that none of his children objected in any way to his will. And
well, then he would have been better off leaving something to the disinherited brother, because then he would have lost that.
You're absolutely right, Your Honor. I mean, I always talk to people about the fact that these interim clauses don't do any good if you've admitted somebody and you didn't leave them anything.
Right.
Because then they have no incentive. They're going to bring an action.
Right, but if Sean or whoever does not actually put their name down as a plaintiff, then what's the purpose? We don't just do things arbitrarily. What's the injury? What are we serving?
I think the injury, Your Honor, is allowing just what happened here, is Sean was upset by this will that had changed from the previous will, and he talks about that in his affidavit. And so it allows somebody that did receive something under the will to challenge the validity of the will and say things like, my father had dementia, my father was not capable of making these decisions. Those are the things that people don't want brought to court when they make these kinds of clauses in their wills. They want to keep their life private and not have these issues about their personal well-being brought before courts. And so that's the harm. The harm is to all of the other people out there that put these clauses in their will to protect themselves and protect their privacy, which part of the affidavits that you see in this case talk about. That was important to him.
That's exactly what I'm concerned about, though, is that, we do see many of these cases, particularly where one or two siblings really care for the parents and the other ones don't, and then suddenly people seem to feel some real entitlement, and I am getting that.
Right.
But then you're creating this situation where someone could violate a clause like this by literally just saying to a friend, I really think Dad didn't have the competency to make this will, but doesn't actually go to court.
But this person did go to court, Your Honor.
Well, he didn't go to court. He was
did.
sort of foolish or naive, right? I mean, I don't know, do we have to credit him where he says, I told the attorney I didn't want this to bite me in the behind?
Well, Your Honor.
Not quite as nicely as I put that.
Very nice. But I think, Your Honor, that there was a participation of Sean in supporting his brother that went beyond what he needed to do to assist his brother in this portion of the case.
So you think that providing helpful support is the equivalent of join in for purposes of this clause?
Depending upon how far it goes, Your Honor. And for instance, what I was saying earlier, if he had just, kept it to, my brother Tom misspoke about whether or not we knew there was another will or that. If he left it to that and didn't get into the specifics of Dad, I think that's true.
What if
But
he wrote,
was trying to promote.
I love this will, it's a great will, I hope it gets probated, but I have to admit that Dad was totally out of it at that time. I talked to him many times and, he didn't know north from south, up from down.
Again, Your Honor, I think that statement, I like the will, but, my dad really was incompetent, does question the validity of the will. And so if you're putting statements in
It questions the validity, but the question is whether it joined in.
I think supporting
Is the equivalent of joining in. Your answer to my earlier question is
the
yes.
equivalent to joining in, Your Honor. Yes. If there are no other questions,
Seeing none, thank you.
thank you very much, Your Honor.
That brings us to the sixth and final case on our hearing list this morning, case number 2023 P665, ERIN and Diorio versus John G. LaLACHEUR.
All right, good afternoon, Your Honors, and may it please the Court. My name is Francesca Papia, and I represent the defendant appellant John LaLACHEUR, who currently serves as the Chief of Police for the City of Beverly. We respectfully request that this Court reverse the Superior Court's order denying his motion for summary judgment because he is protected by common law immunity from the plaintiff's invasion of privacy claim for the following reasons, which I'll address in turn. So first, his actions were discretionary and within the scope of his official duties, and there is no evidence from which a reasonable jury could infer that he acted in malice or in bad faith or corruption towards the plaintiff. Yes.
Oh, I'm going to pause you there because we're in a summary judge, or well, a motion to dismiss context. And there does seem to be maybe a factual issue, and so that's not great because the plaintiff is saying that the defendant never produced the most wanted poster, and that the thing he did post, arguably by mistake, is so different that that becomes relevant. So is the most wanted poster in the record?
Yes, it is.
It is. Where is that?
So I don't know exactly where it is off the top of my head. I know that it was
158.
Thank you.
Thank you. Yes, so it was produced, and it also does look similar and again, there's no evidence to actually support that these two things looked completely different to support the plaintiff's position on
Is
that.
there a reason we can't compare them by looking at them side by side?
Of course, you could most definitely do that.
They look pretty different.
Well, again, it's something that was small and pulled up on a phone during an active manhunt. Again, the only evidence in the record is that he mistakenly attached the wrong document. And there's nothing on the other side to support that this private information was intentionally attached to the tweet.
So what was the private information? Because there was a lot of words, but could we just boil it down?
The private information was the plaintiff's name, her address, and her son's daycare.
Okay.
All right. And so going on to say there are no disputes of fact here. I know that the plaintiff attempts to create several disputes. However, there is no evidence in the record to actually support these disputes of fact. And again, I'm going to just now go into my first argument with respect to discretion, and that the chief's decision to post the tweet was in an attempt to apprehend Dixon and to also alert the public of the dangers that Dixon posed.
So sometimes we pose hypotheticals to see like how,
of course,
far-reaching you're looking for. So if, let's assume for the moment that he wrote a writing that he could post on this, his personal chief account, but like he's just a known Butterfingers, as some of us are. And so he's mistakenly posted the wrong thing like 2 times before. But then he keeps doing it. Like, is there a point where he's screwed it up a couple of times and we're just like, nope, you cannot use the technology, my friend?
Well, I guess it depends on if in that hypothetical, whether the mistakes before had resulted in invasion of privacy
Well,
claims.
I'll make it a very simple example. That we all have worked in offices where somebody had a reply all problem, right? And at some point you got to say, you either need to figure this out or you can't use email. Like, it's one of those, but you cannot keep replying all.
Right.
Right.
Totally necessary for defeating common law immunity and showing that there was a malicious intent or that he was acting in bad faith.
Judge Henry's hypothetical was designed to take you up the ladder from negligence to possibly gross negligence, maybe recklessness at some point.
Right.
We're dealing here with a contention that he posted intentionally, which is what would get through immunity and subject him to potential liability. You say it was an accident. She says it was intentional. And at this stage, on this record, how do we tell the answer to that question?
Well, there's nothing to support that this was done intentionally.
But there's nothing to exclude the possibility that it was. Isn't that what the discovery and litigation process would be designed to do? If she has a reason to believe that it was done intentionally, despite his protests to the contrary.
So, but even when you're dealing with common law immunity, just this conclusory allegation that he intentionally did that, that is not enough to go forward to a trial to determine whether the defendant, the public official.
What's confusing to me is if he's negligent, he's got total immunity under the Tort Claims Act. So the only way we're going to get to common law immunity is if we assume it's intentional, because intentional is the only thing that common law immunity applies to.
Right.
So you keep saying it's negligent, and there's a lot of evidence it's negligent, but don't we have to assume it's intentional for purposes of applying the common law immunity?
So even accepting the fact that it is intentional, intention does not rise to the level of bad faith, malice, or corruption. So bad faith imports a dishonest purpose. It's immoral. It's a conscious wrongdoing. It partakes the nature of fraud. There's no evidence here that Chief LaLacheur was dishonest, that he was immoral, that he had any desire or ill will to defraud the plaintiff. And also,
Right, so, but this is why the plaintiff argues, look, the department had a policy, and it had an official Twitter account, and it had, I sort of find this a little bit hard to believe, but one single police officer who apparently maybe is available 24/7 for a manhunt, but is the only person who can ever post to that account, and that somebody was a decision maker to say that, you know, a Twitter account in the hands of a Luddite is going to cause exactly what happened here. That's why we don't allow it. And so him overriding that is, in fact, the intent.
well, he didn't override any policies, though. So as the department head and the appointing authority of the City of Beverly Police Department, Chief LaLacheur did have authority to post to his own chief's Twitter account in circumstances like this.
You're not saying that he issued a writing that he was authorized to do it. You're saying by his action, he implicitly authorized himself.
By him being a department head, he implicitly was authorizing himself to do this. And this was a circumstance that was a rapidly urgent situation, and he made the decision, and this isn't something that had happened before.
All right, so you're not saying he had discretion to disseminate her personal information. Your argument is he had discretion to put out a most wanted photo.
Exactly. So the issue here is not that he had discretion to disseminate the plaintiff's private information. Of course he didn't. The issue with respect to discretion is that he had the discretion to post tweets in furtherance of his official duties as chief of police, and that includes warning the public about dangerous situations.
And what you're saying further is that the fact that he, in the execution of that act, the fact that he disseminated something that had he recognized it for what it was, he would not have posted it.
100%.
He posted that, and the plaintiff's injury was a consequence of his poor execution of an otherwise authorized act.
100%. I think that the Nelson versus Salem State College case is helpful on this issue. So in that case, a college employee brought an invasion of privacy claim after she found out she was videotaped by a hidden camera as she changed her clothes and applied sunburn medication to her chest and her neck. And so in that case, the defendants were responsible for investigating criminal activity on the campus. There, the SJC held that the defendants were protected by common law immunity from the plaintiff's invasion of privacy claim because they acted within their discretion in using a surveillance camera in an area where criminal activity was suspected. Now, when you look at that case, the defendants in that case did not have the discretion to videotape the plaintiff employee while she got undressed, changed her clothes, and applied sunburn medication. Again, it was only that they had this discretion to use a surveillance camera in order to, investigate criminal activity. When you look at it and compare it to this case, it's very similar in that Chief Lasher
reviewing that footage and sees that she's starting to change clothes, was there discretion to keep watching?
No.
Okay.
All right, so also going on, again, the most important thing here is that there needs to be evidence from which a reasonable jury could infer that Chief Lasher acted with malice, bad faith, or corruption. And there is none of that, even accepting for purposes of this argument that he acted intentionally.
Well, but this is why this question about him authorizing something, if he had pre-authorized it in writing, then you would know it wasn't specific to her. But, or if he had, if in this record there's evidence he had previously posted this kind of information from his Twitter account. But, otherwise, we're in a situation where he just says, well, I just thought it, and therefore you have to believe me that it's true.
And I'm sorry, can you repeat the first part of your question?
Well, it seems like there would be greater protection in this situation if he had executed a writing, when he saw this policy.
Okay, and do you mean executed a writing to himself, authorizing himself to, okay.
Well, one option would have been to just say the chief of police always has authority to do this, but somebody, I don't know who promulgated this policy, but somebody apparently sagely realized oopses could happen. And so if he had said, oh, I'm authorizing myself, and everyone else in the department was like, oh my goodness, we can't let him, no, something bad's gonna happen. The whole point of this policy was to avoid exactly this situation. So
Okay.
if he had said, I am authorizing myself, then somebody could have said, then you have to go through a training, my friend, so that you don't screw this up.
Mm-hmm. Well, so also another thing about this policy is it's a revised 2018 policy.
It's a what?
A revised 2018 social media policy. This incident actually took place in 2017.
Do we have the 2017
There is,
policy?
I don't believe there's a 2017 social media policy. Either way, though, even if, he did testify, and the only evidence that is not disputed is that he had the authority, as the department had, to communicate with the public, because his official duties are to communicate with the public and notify them of certain public safety issues.
What you just said seems very significant. What's the record evidence this policy didn't exist? Because I'm guessing maybe then the policy was promulgated.
We're just accepting it as if it did.
You are accepting it as if, okay.
So the other key thing, though, is even if this court were to determine that Chief Lasher had exceeded his authority, that still does not constitute the requisite evidence of malice, bad faith, or corruption.
Which is why I go back to the beginning. At some point, if you keep making mistakes, then intent has to be attributed to you.
Right, but at the same time, this isn't a situation where he had kept making a mistake. This is a situation that it was the first time where they were dealing with an active manhunt to this extent. And the fact that Dixon posed such a serious threat that there was this full-fledged active manhunt further underscores the need for immediate and swift communication to the public about what was going on, which was what he was intending to do. All right, well, if there are no further questions, I rest on my brief.
Just quickly, so he agrees he does not have access to the department's official Twitter account, and he wasn't authorized to post to that?
He is authorized to post to it, he just doesn't have the login information.
Okay. Okay.
Thank you.
Thank you. For the appellee?
May it please the court. My name is Stephen Corin, C-O-R-E-N. It's a privilege to argue before this court today, and if the court is ready, I'll proceed with my argument. And in the court trying to reach a decision on this case, I believe the premise should be to look at this through the lens of summary judgment. This is not an appeal from a trial. The defense, appellant, has raised questions about the value of circumstantial evidence and that it is not worth anything, things like that. That is not what this case is about. There are two issues. Number one, is there a dispute of any material fact? And there is. And number two, is qualified immunity a privilege for this officer or not? And we argue emphatically it is not. For the standard of summary judgment, Your Honors, it is the plaintiff's obligation only to secure a toehold, to approach a prima facie case, not to prove their case.
So what is the dispute of fact?
I'm sorry, Your Honor?
What is the dispute of fact?
The dispute of facts are a number of facts, Your Honor. Probably the ultimate fact in dispute is what was in the chief's mind when he sent out that tweet. However, all the evidence, including argument of opposing counsel, says it was intentional. Intentional, as defined by the McGurk case, which is in their brief, defines qualified immunity as to whether or not the act was intentional. It doesn't have to be evil. It does not have to be designed to hurt somebody as its only purpose and consequence. Other facts in dispute.
What about the act needs to be intentional?
I'm sorry, Your Honor?
What about the act needs to be intentional? Is it simply the affirmative decision to press send, or is it an awareness of the content, which, according to the appellant, is not what the officer intended to send?
A good question, Your Honor. I would respond by saying that, first of all, this department is bound by the Massachusetts rules of regulations of domestic violence, which they had to adopt. Also, Chapter 209A, which defines abuse in the situations where there is abuse and the type of
There's no question that what he sent, he should not have sent. The question is what the evidence is that he was aware of what it was that he was sending.
I see, Your Honor. I misunderstood your question. I can't tell. I don't think the evidence shows whether or not he knew what was in the tweet during his deposition.
So why isn't that material?
I think it's material that because of the obligation of a police department, they cannot release confidential information about a victim of a domestic violence situation. Either they read it or it's presumed they know it and they don't send it to
You
public.
seem to be saying then the standard is they can't make a mistake, and that can't be the standard.
I'm sorry, Your Honor?
You seem to be arguing the standard is that the police cannot make a mistake in these postings.
Or that there's strict liability. And,
when it comes to this area of confidentiality, as opposed to the cases the defense cited as to proper police procedures, such as in the Nelson case, doing a surveillance of a store to prevent theft, that's a recognized police procedure. That
pose another hypothetical.
Discretion.
Let me pose another hypothetical, because I just want to be sure we are narrowing in on this. Let's suppose that that an officer leaving the station at the close of regular business hours is required to lock up. But on a particular Tuesday, they leave and they forget to lock the door. And someone discovers that the door is unlocked. They go in and they rifle through the files and they pull all kinds of damaging confidential information that ought not to be revealed to the public. The officer who neglected their duties to secure the facility, are they liable?
I don't know, but I would think that would come under the heading of mistake.
I wouldn't either. And so the mere fact that through negligence, confidential information made its way out into the public domain is not a basis for liability. The standard here, I thought we understood, is malice or bad faith. And I'm asking, we know that what went out was, shouldn't have gone out. What we don't know is whether the officer was even aware that what was going out was what it was. And if we don't know that he was aware of what he was sending, how can we find even a toehold to support malice or bad faith?
My position is, Your Honor, on behalf of my client, the officer is held to be aware, just like he was held to be aware.
Well, no, hold on. So, wait. So when we get to trial.
I'm sorry?
When we get to trial, you're going to have to prove he knew what he attached, right? Or can you just tell the jury he's held to know?
I will show the jury the tweet. It'll contain the prohibited information. My argument to the jury would be he's held to know what's in that tweet. He wasn't authorized to send it in the first place, and if he chose to do it on his personal phone, he had to know what was in that tweet.
Why?
So,
Where is the principle of law that charges him with inescapable knowledge?
I believe, Your Honor, my answer to that would be he must be aware of the existence of Chapter 209A and the department regulations as to confidential information regarding victims of domestic violence. The burden is on that officer to make sure he does not tweet that information.
No, that's what you are saying. What I'm asking you for is an identification of a case, a statute, or a legal principle that supports your assertion that he is charged inescapably with that knowledge.
I would assume, no, I don't have a specific case, but I have to make the assumption, and I think a jury can be instructed to infer, at least, that a police officer must be aware of information.
If I'm the trial judge and you ask me for that instruction, I'm going to ask you for law to support it.
I understand, Your Honor.
Okay. So we're back, as they say in the old, we're back to third base.
Perhaps.
So, but
in the example,
I'd like to narrow some of the things, though, that are not in dispute. Is it correct that the chief had never met your client before and never had any interactions with her before?
I believe she had interfaced with the department, but I'm not sure that he knew her personally.
Okay, and do you agree that if he had only actually tweeted the wanted poster, that would have been okay?
Yes.
And do you agree it was his decision to post something, forget that he made the mistake, but his decision to post something to apprehend Mr. Dixon and protect the public was a discretionary one?
No, I don't think it was discretionary. The poster would have been, but not the tweet containing the information about my client.
No, I'm asking just the decision, I'm going to post something to apprehend, I hope, help apprehend Mr. Dixon. Is that a discretionary decision?
Depending on the information, yes.
All right, but she argues, for the Nelson case, that they had the discretionary decision to put a camera in this area that was, I'm not going to say it was public, but it certainly wasn't a changing room or a bathroom or something. So they put this camera on and they catch this police officer disrobing.
It had to be a private area because she undressed. She also rubs sun-tanning lotion on her chest area.
Right.
Yes, Your Honor.
But if they knew, but she's saying, so that case is controlling here, that if you're right, then the decision would have had to have been to film her, and that's not the decision we make. The decision is the decision to take a general action, was their authority, that it doesn't cover a mistake.
I think that case cannot stand for the proposition which is being argued by opposing counsel, because the issue was decided on Fourth Amendment and 1983 issues, which are totally different from this case. I think that case bears very little precedential weight in terms of facts and law, Your Honor.
It says they are shielded from liability by the doctrine of common law immunity.
I'm sorry?
It says they are shielded from liability by the doctrine of common law immunity, which I thought was what we were discussing here.
Yes.
Yeah, the source of the
Why-
underlying liability is not as important for our purposes as whether it's immune or not.
Yes, Your Honor.
So there is an argument between the two of you as to the burden of proof, and she is saying, your learned colleague here on the other side is saying that the SJC has said that our decisions are uniform in that holding that once immunity has been invoked, the burden of overcoming the immunity rests exclusively with the plaintiff. What do you say to that?
Well, I have some concern about that, Your Honor, because pleading qualified immunity is an affirmative defense. That raises the question as to whether the burden should be on the party claiming the immunity, which is what case law holds. In addressing my argument, Your Honors, I understand the concern of the court. However, I do argue that the act of the officer, I think, as to what was treated, the bottom line is, was his act intentional? And if it is claimed that he wanted to alert the public to some sort of danger, then that's intentional.
Why isn't the bottom, but if it's intentional, I thought the bottom line was, is it malicious?
Was it what?
I thought the bottom line was, is it malicious?
I didn't understand the last word.
I thought the bottom line was, is it malicious? Isn't that what you have to prove to defeat common law immunity?
I don't think that has to be proved, Your Honor, most respectfully. Under McGurk and the line of cases from McGurk, intentional has been held to be equated with malicious.
Well, so if common law immunity only applies to intentional torts, and the fact that it's intentional defeats common law immunity, am I imagining common law immunity? I mean, how can that be?
I don't understand your question.
Common law
Sorry, Your
immunity
Honor.
only applies to intentional torts, right?
Yes,
And you're saying the fact that it's intentional defeats the common law immunity? Is that what you're saying?
absolutely, because that's what McGurk says.
So what does the common law immunity do if it only applies to intentional torts and doesn't apply if the act's intentional?
That is correct, Your Honor. In the facts of this case, the proof has to be that the police officer acted intentionally, not negligently, not gross negligently, and he had, and even the purpose to disseminate the confidential information served no purpose whatsoever other than to expose the victim to danger. That tweet identified her name, her address, the place where her child went to school, and the pickup time, and the perpetrator threatened to kill the child.
What's the danger, though, in terms of the perpetrator? Are you meaning danger to other people? Because the perpetrator already knew her name and already knew her address. That was the allegation. I'm unclear whether the perpetrator knew about the daycare, but the whole point was allegedly the perpetrator had just damaged her home. So that was not new to him. So are you claiming there was injury to her because other people in the public?
One could argue that it's been a known police practice in this country to use a victim as bait. But in tweeting this information, there was absolutely no purpose to disseminate this to the public, to alert the public that there was the danger of a perpetrator being in the area. Those were two different things.
So in Nelson, if there had been discretion to film Area A in the police department because of some theft problem, but by mistake, one of the officers put the camera on Area B, would that be actionable then under your theory?
I believe it would.
Anything further?
I would sum up, Your Honors. I thank you for your kind consideration. There are material disputes of fact, including whether or not, as you've raised, whether or not the police officer knew what he was tweeting. My recollection of his deposition was that he was aware of the information in the tweet. There also was a dispute in the facts as to what he was sent by the communications officer from the Beverly Police Department. He had originally claimed he got the poster, a picture, in an email, and then the tweet. Further evidence showed that he never received the poster. So it wasn't that he chose the wrong thing to tweet. He had just one document, and he disseminated it. The steps he had to take to program his personal phone to send that out was at least 4 different steps. We argue that's evidence that it was intentional, and he was responsible for the information that he sent out into the public. And I think this is not a matter of him making a mistake. It's a matter of him intentionally sending out protected information, and it's the highest level of confidential information based on all the guidelines and state laws that the police officer was held to know. Finally, I would say, Your Honors, the statute in question...
Your time has expired. Thank you.
I'm sorry, Your Honor.
That's
Thank you.
well argued on both sides. That concludes our session. We are adjourned.